So why did you do this?
I was going through some stuff,
What were you going through?
financial stuff, and then I was having a lot of health issues at the time also.
Okay, let me ask you this. And I ask these questions because I want people to think about the actions they're taking, right?
This hearing centers on an explanation offered after the fact. The issue is whether personal difficulty can substitute for responsibility. The court is not weighing intent, but accountability. Watch how the judge examines that assumption.
All right, the court is calling 2025 CR 006953, State versus Crystal Velas. Could I have parties announced?
Daniel Gutierrez for the state.
Roberto Ambrosino for the defense.
And are you Ms. Velas? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and did you sign it? Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
To the clerk, do you have a copy of the indictment?
Oh, you know what, Judge?
All right, counsel, you're waiving the reading of the indictment?
Yes, Your Honor.
And state, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments? Oh, do you guys need anything?
No. I think I put, there was a restitution document. I think I put it in the plea paperwork. I was
Yes.
supposed to give it to my client.
Do you all need this?
I think I need to give it to her to pay.
Okay,
This is my mistake.
that's okay. All right, did you review the court admonishments with your attorney? Did you understand it? All right, let's go off the record. Charging,
At the outset, the court methodically confirms discovery compliance, plea paperwork, and the defendant's understanding of the process. This establishes that the plea is not rushed or informal, but deliberate and procedurally complete. The tone is administrative, signaling that the court expects clarity and accountability from both sides.
on count one, because the court's docket has 3 different counts in it.
There's 3 counts in the indictment, Your Honor.
So are you proceeding on all 3 counts?
All 3 counts are part of the plea, yes, Your Honor. And maybe it's like 2 of them need to be closed out. They're separate in Odyssey. Is that what you're saying?
No, I mean, if y'all are proceeding on all 3 counts, then y'all need to, so that the record can be clear and so that we're off the record, so that the record can be clear and she can know what she's pleading to. If y'all are proceeding on counts 1, 2, and 3, do y'all agree there are 3 counts?
There is, I mean, it's supposed to be deferred. So I mean, it should.
No. I mean, she'll need to enter a plea to all 3 counts. And if all 3 counts are the same level felony,
Fair.
y'all need to put it in your plea paperwork. Okay. So if y'all will step back, and when you all are ready, I will take you out.
When confusion arises about whether the plea covers 1 count or 3, the judge stops the process to correct the record. This moment reinforces that the defendant must clearly understand each charge she is pleading to. The court's insistence on precision reflects how seriously multiple felony counts are treated, even within a deferred framework.
And are these counts to run concurrently? All right. And my understanding states you're proceeding on all 3 counts?
Yes, Your Honor.
All right. So did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right. You're charged with misappropriation with a fiduciary duty of financial property, $2,500 to $30,000. Money laundering, $2,500 to $30,000. And securing a document through fraud, $2,500 to $30,000. All of those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in.
The judge formally outlines the charges: misappropriation with fiduciary duty, money laundering, and securing a document through fraud. Each carries potential jail time despite the deferred adjudication request. This explanation grounds the case in its legal reality, making clear that leniency still carries significant risk if conditions are violated.
State jail facility and up to a $10,000 fine in each count. Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Velas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed to re-enter into the United States, and denied naturalization. Do you understand? The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on counts 1, 2, and 3. There's a $500 fine to be probated. Counts 1, 2, and 3 were run concurrently. The state is recommending deferred adjudication. There's to be restitution of $17,215.37, of which $5,000 is to be paid before the court sentences you. And that is to be payable to Calton, Calton Investments, Inc. Did you understand that to be your plea? Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
There have none.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years.
The plea agreement introduces concrete consequences: restitution exceeding $17,000, probationary fines, and 5 years of community supervision. The court emphasizes that these are recommendations, not guarantees. This distinction underscores that deferred adjudication is conditional trust, not dismissal.
There'll be a TAP evaluation, 96 hours of community service restitution, no contact with 400, is this an M or N?
It's an N, Your Honor.
400 N apartments, Springwood Apartments, Trina Meyer, Delia Brodniks, Marilyn Meyer, and Brent Meyer. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to count 1, how do you plea? Count 2?
No.
Count 3?
No contact.
State any evidence to support the defendant's plea?
And at this time, Your Honor, state offer states exhibit 1. I believe it's already in front of you.
No objections.
All right, did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of count 1, 2, and 3. Court would defer finding of guilt as you've applied for deferred adjudication. So when are you going to be able to pay this money back?
I'm sorry?
When will you be able to pay?
She was able to come up with 5,000 up front that she has today.
So when are you going to be able to pay this back?
No. She just wants to know how long.
How much are you thinking you can pay per month?
I think we can pay at least $400.
So this is what the court is going to do. You've paid 5,000 so far. Has that already been paid?
Money.
She has it with her and she's gonna,
All right. So,
They haven't turned it over to me yet, Your Honor.
all right.
because they didn't ask for it, but we do have it.
All right.
That's fair.
Yeah, we have.
They're not. I didn't fill it.
All right. And is that 5,000?
Your Honor, just for the record, it's 2 money orders, both in the amount of 2,500 each.
All right.
And they are made out blank, so they could be.
Just what I instructed her.
All right. So when are you able to come up with $2,215.37? I'm sorry, what?
Maybe December, a little before.
All right. So I'm going to bring you back for sentencing, and I'll notate that you've already paid the $5,000, but you're coming back for sentencing. All right. So we're coming back for December 1st for sentencing. At that time, you need to be prepared to tender.
The discussion turns to restitution logistics, with the judge pressing for realistic payment timelines. The court acknowledges the upfront $5,000 payment, but focuses on whether continued repayment is feasible. Accountability here is measured not by promises, but by demonstrated follow-through.
$2,215.37. All right, Ms. Ferguson will give you a reset form. All right, you entered into a plea on September 29th to counts 1, 2, and 3. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for the deferred adjudication. According to your plea bargain agreement, there's a $500 fine to be probated. The counts are to run concurrently. There's to be $17,215.37 to be paid to Carlton, Calton Investments, Inc. The defendant paid $5,000 prior to entering into the plea. And today the defendant paid $2,215.37. Is that correct?
That is correct, Your Honor.
Yes, Your Honor.
And the $7,215.37, is that towards the $17,000?
I think that's not including the original 5,000, Judge, but the 2,215 that gets us to an to 15,000.
Right. All right. Is there anything you wish to say?
No, ma'am.
Again, you're whispering.
Sorry. No, ma'am.
All right. So why did you do this?
I was going through some stuff,
What were you going through?
financial stuff, and then I was having a lot of health issues at the time also.
Okay. Let me ask you this. And I ask these questions because I want people to think about the actions they're taking, right?
Yes, ma'am.
So what if everybody who was going through some things and had some financial problems decided to steal?
It's not right, and I'm sorry.
And because of what you've done, now you're going to have more financial difficulties. And the reason why you're going to have more financial difficulties is because now you're going to be on probation, which means my clients, they would always say, I want to get off of paper. What that means is you're going to be on paper under a contract with the court. The crime that you committed is a crime of moral turpitude. Your attorney will explain to you the impact that has on any type of career that you would be seeking. So anything that requires a license, this is going to negatively impact that. Are you currently employed?
Yes, ma'am.
What do you do?
I'm a leasing agent.
And are you handling money for them? And when you say you're a leasing agent, what do you do?
I make sure I gotta lease out the units.
When asked directly why she committed the offense, the defendant cites financial and health difficulties. The judge responds by reframing the issue, explaining that hardship does not excuse theft and often compounds future consequences. The exchange highlights the moral dimension of fiduciary crimes, especially when trust and employment responsibilities intersect.
Partners.
Okay. And do you have any children?
Yes. I have one.
Age?
Oh, he's not little. He's 20.
He's 20. Do you have any grandchildren?
No.
That's a good thing. It's always nice when you have a 20-year-old and you don't have grandchildren yet, I guess. All right, probation, counts 1, 2, and 3 is to run concurrently. There's to be regular reporting by Zoom or in person, regular random UAs. You can either do regular random UAs or the patch. The patch costs more. I think the patch is about $300. What happens with the patch is probation will put it on and you don't take it off. Probation will take it off. You can shower with it, but if you tamper with it, that's going to be a violation. The thing about the patch is that it frees up more time because you don't have to go to the office to do a drug test.
Okay. So I just tell them which.
Yes. And they'll let you know. Who knows, the price may have gone down. They may have a program that can help pay for it.
Okay.
There's going to be field visits 1 time per month for 6 months. Proof of employment within 45 days. No employment as a home health care provider or with minors. There's to be restitution of $15,000 to Carlton, Carlton Investments, Inc. Now, with regards to that $15,000 that is owed, how much are you able to pay towards that monthly?
Monthly, I would say about $350.
All right. So she's to pay $300 per month towards the $15,000. There's to be no contact with the following: 1,400. There's to be no contact with 1,400 North Apartments, the Springwood Apartments, 5 years deferred adjudication, $500 fine, and that will be probated. And there's to be 100 hours of community service restitution. I'm going to require a money management course. Once you complete that, the community service hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court to be successful?
Oh,
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and
Yes, ma'am.
sign it?
yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing in this court. In order to be successful on probation, communication is key. Do not disappear. Do not stop reporting for probation. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back and address it with me.
Okay.
You understand?
Yes, ma'am.
All right, probation will go over conditions with you. Make sure that you pay that $300 per month, okay?
Yes, ma'am.
All right, good luck.
The court accepts Crystal Velasquez's plea to all 3 felony counts, grants deferred adjudication, and places her on 5 years of community supervision with restitution, fines, employment restrictions, and mandatory financial management conditions. This case illustrates how courts distinguish explanation from justification, particularly when financial hardship collides with fiduciary trust. Follow for continued, fact-driven courtroom analysis focused on accountability and legal process.